This regard. This is the live video of this session on point of legitimate expectation. No one is aware, but someone is aware of this very fact, what actually the legitimate expectation is. So now let's discuss in terms of the historical approach or the origin of that very term. The doctrine of legitimate expectation was first developed in English law as a ground of judicial review. And judicial review is quite clear to you exactly from the side of the Marbury versus Madison 1803. In earlier case law, this is the establishing approach from the side of US case law that the Supreme Court from the side of the Chief Justice Marshall prescribed regarding this aspect. So judicial review in what ground exactly, on what point, and which law prescribed this regard, in this regard? Of course, there is no doubt in administrative law to protect procedural or substantive interest. There are two types of interest at all. Those interests should be protected by the legitimate expectation. For example, in bar council exam, for example, those who are the candidates who passed in that very 2017, at the time, what can say, notification will, what the approach will be discussed through the authority bar council that those who are the candidates who will pass actually from in 2017, they need not attend their written exam, MCQ exam 2020. So this is the expectation of a human being or the people, those who are the bar council candidates, they have hope in their hearts. Okay, to protect a procedural or substantive interest when a public authority resents from a representation made to a person, it is based on the principle of natural justice. So what is natural justice exactly? We have no power to understand this, is whether this is the natural justice or not. So the natural justice principle prescribed as how can we actually or the alternative paradigm should be prescribed in the society in crisis area or the crisis moment. Okay, this is totally pulled that from the mouth of mine in earlier class, that the Monica Gandhi versus Union of India. So the natural justice phenomenon and fairness and seeks to prevent authorities from abusing power. Not to abuse power at all. The courts of United Kingdom, have recognized both procedural and substantive legitimate expectations. A procedural legitimate expectation rests on the presumption that a public authority will follow a certain procedure in advance of a decision being taken. While a substantive legitimate expectation arises where an authority makes a lawful representation that an individual will receive or continue to receive some kind of substantive benefit. In determining a claim for a least base of a legitimate expectation or the valid hope of a human being, a court will deliver it over three key considerations. What exactly the delivering process? That the three considerations is whether a legitimate expectation has arisen. Number one. And then number two, prescribe whether it would be the unlawful for the authority to frustrate such an expectation or the hope or the valid hope. And it is found that the authority has done so. What removes, what the remedies exactly, what exactly the remedies are available to the aggrieved person. So there is a distinction between the aggrieved person, whether actually how can you find out whether he or she is aggrieved or not. This is the first landmark decision you have already focused, and we of all are aware of this fact, that is Dr. Mohiuddin Farooqi versus Bangladesh, 49 DLR Appellate Division, page number 1. So in this case, aggrieved person, the term aggrieved person does not mean that personally aggrieved at the same time and every time in his leading life or her life. Of course, there is another caption may be attached to that very case like this: whose heart bleeds. whose heart bleeds, they can be traumatized to the active person. So this is the very, what can say, clear cut or lucid in nature in front of us, that whether this is active person. Procedural legitimate expectation have been recognized in a number of common law jurisdictions and contrast notwithstanding their acceptance and protection in the UK, substantive legitimate expectation have not been universally recognized. For instance, they have been given effect in Singapore but not in Australia. This is a substantive expectation. This is totally found in Singapore, but someone who wants to make this country like Bangladesh, like Singapore, this is not possible at all. So Singapore practices the substantive, what exactly the expectation, substantive legitimate expectation is being practiced in Singapore, but this is not found in Australia. So how can this is a recognizable media? This is very much difficult for understand what actually the legitimate expectation is. So now the discussion origin and basis of the doctrine exactly since its inception. There are several landmark decisions in our country, like the state versus what exactly the legitimate expectation case law in our country, several case law. But the history prescribed that the origin prescribed that, or the basis, of course this is the basis. Since the inception, the doctrine of legitimate expectation has been viewed as an offshoot of natural justice. But I don't know offshoot of natural justice. The duty to act fairly is a co-tenet of administrative law. This is being practiced. This what can say doctrine is widely used in administrative law. So those are the authority who actually prescribes towards the human being. There is a tendency to create any expectation, whether this is the valid expectation of the hope in the human faculty or the human's heart, that should be actually focused to the under in our country, not in UK, not in what can say, like this is the first case law in UK. This is the Wednesbury unreasonableness or the fair abuse of power. So the first judicial review and public law, like this is the landmark decision. This is the case of Scheminet versus Secretary of State of Home Affairs, 1968. This is the first case law where it is found that the legitimate expectation is what can say. This is the landmark decision where it is found that the term legitimate expectation was first used in the case of Scheminet versus Secretary of State of Home Affairs, 1968 in UK. So that should be kept in your CPU. And then second case law, O'Reilly versus McMahon, 1983 maybe. This is the second case law from UK that can be widely discussed in terms of legitimate expectation. And another case law, Council of Service, Unions of Minister of Civil Service. This is the GCHQ case, 1983. And then fourth case, which will be immersed in this regard, that the legitimate expectation R versus Nutt and Eastern Devon Health Authority, Experty, Culligan, 1999. Oh my God. So those are the landmark decision in terms of legitimate expectation, which is widely practiced in UK. So legal framework, originally this is the origin from the English law exactly, and then several times, but the limitation prescribed in every sector, Australia prescribed, Singapore, USA, and even our country like Bangladesh will practice in taking this red jurisdiction under Article 102, Subarticle 2. This is when a person will be aggrieved at the time there is option to go to the High Court Division to take any remedy in tracking this approach power as to the legitimate expectation. That is totally the red jurisdiction. And not only that, earlier I have already focused in this regard, like Dr. Mohiuddin Faruqi versus Bangladesh for the 9-day appellate decision, prisoner of war. And not only that, Qazi Mukhlisur Rahman versus Bangladesh, this is well known to you, this is the Berubari case. And not only that, it will be limited versus Chaudhuri Mahmoud Hassan and Italian Marble Wax Limited, that the Moon Cinema, there is the Helen, what except the dreaming women of Halal Hafiz is Helen. So this is the owner of the Moon Cinema Hall. So this is the tagging, this is the Fifth Amendment case, you have all Actually, you of all are aware of that very fact. So how can you actually, this is the dimension in the limitation of that very expectation of the legitimate expression is that the alter virus. When the alter virus process may be come forward at the time, we have to back to the pavilion. There is no option to exercise the legitimate expectation. So this is the limitation to use this that term like this, the tracting legitimate expectation. So it is very much important. Not only that, several, whether this is the shape to development of substantive legitimate expectation or the reconsideration of decision damages. What exactly the Moon Cinema Hall, the owner of that Moon Cinema will be damaged, and the damages will be fired to him. So this is very much important for you, how to actually understand the legitimate expectation. There are several doctrines. Day by day, I will discuss in terms of that, whether this is the legitimate expectation, whether this is the doctrine of eclipse, or the doctrine of basic structure, doctrine of phasor. Day by day, I will discuss on point of them. So no matter how I saw that, those are not difficult to understand. This is the legitimate expectation. And Australian case, UK, after UK perspective, if we of all go through the Australia, then we will find besides applying in UK, procedural legitimate expectation approved in Federal Court of Australia. The Federal Court of Australia practices this is the tracting. In the first leading case, that's Minister of State for the Industry and Commerce. What exactly the first case? GTE Australia Fly Limited versus Brown 1986. This is the landmark decision why it is firstly discussed in this regard, that is whether this is legitimate expectation in other jurisdiction. Not only that, in Singapore, the politician wants to make the country like Bangladesh, like the Singapore. But unfortunately, Singapore practice this the legitimate expectation. For example, how can actually Chiu Tang versus Peter Royal Limited versus Singapore Land Authority 2013, this is the recent judgment, 2013, this is the year prescribed, that's the landmark decision. And not only the first landmark decision in Singapore in terms of legitimate expectation is that Abdul Nasir bin Ahmed Hamza versus Public Prosecutor in 1997. So 1997 to the 2012, that the ease of Janji. So what exactly this is the recent trend in Singapore, and not only that, the recent judgment Chino Chanka Kullang Ferry Limited versus Singapore Land Authority 2013. So this is the what exactly the recent judgment in terms of the legitimate expectation. So legitimate expectation prescribes there is a reasonableness, that the just and fair, but this applicability in terms of administrative law. So whether always administrative law or not, that should be focused. This is the ease of what can say science, and this is the ease of the tangent. So how can we actually Singapore practices and Bangladesh practices at one? So how this Bangladesh practice in this case, the recent trend in this regard is this is the legitimate expectation. In Bangladeshi case law, this is what exactly the Article 102. And not only that, in 2020, this is the landmark decision in terms of the state versus Abdul Razzaq and others. So what exactly the landmark decision? The Secretary Ministry of Fisheries and Livestock and others, what exactly the Abdul Razzaq and others, Ashrafuzzaman others. Since the Hassan Fayed Siddiqui prescribed in terms of what exactly the legitimate expectation 2020, this is the landmark decision and the recent trend in terms of legitimate expectation. So don't to sound, this is the hypothetical class in terms of the live video class, Mr. So soundproof room should be prescribed by you exactly. So live will be finished in this moment. Why? The reason behind this several case laws will be prescribed by you. Incoming call has been emerged from the side of Mr. Alamin, and that's why this is the live video, and that's why after finishing this, the legitimate expectation should be prescribed in such way. How can actually the country's code like Supreme Court practice in this regard? Legitimate expectation prescribed what exactly the in Bangladesh, Singapore, USA, and the origin of that very term of the doctrine is in English law. So how to actually the practicing power in terms of administrative law. So the authority, for example, in a recent trend, the crying example from the side of the Bar Council, they first up that in those who are the candidates who passed in that very exam 2017 in Bengali 2017, and they have no need to sit any what exactly MCQ exam, those who are attending in terms of 2022. So this is the landmark decision in terms of the state versus Abdul Razzaq and others in terms of legitimate expectation. Hassan Faiz Siddiqui fresh cut several what exact discussion or the direction in this respect, how to use this situation that the three organs show, whether this is the legitimate or not, whether it's free and fair, and whether the practicing approach from the national justice phenomenon that should be prescribed here. So it is quite clear to us several judgments like legitimate expectation practice in Dr. Muhyiddin Faruqi versus Bangladesh, Kazi Mokhlisur Rahman versus Bangladesh, EDB Limited versus Chaudhry Mahmood Hassan and others. Those are the landmark decision in our country. And not only that, the first landmark decision in UK, that should be focused by us to you. Again, please, and 1968, this is the landmark decision first of all, that should be focused here. And again, please. This is the originating case law. This is totally known to you. This is the scheme edit versus secretary. What exact secretary of the state of home appears 1968 synopsis, please. This is the synopsis made. Well, how can actually understand? This is recognizable to you. There is a requirement to understand this. This is the Lord actor in the whole world. Whole world is in point of a Lord actor. So this is not the best law academy, especially in Bangladesh. In the whole world, this plays a significant role to teach the students in terms of legal arena. So today's Namo. Do you see next? Bye-bye.